Testing. All right. Looks like this works. Hi, everyone. Thanks so much for being here. Appreciate you coming. I know people are still filtering in, but we want to get started because we got a lot to cover today. My name is Joel Sayers. I'm a partner here at Fager Drinker in the Denver office. I do IP litigation, and I'm also the office leader here in Denver. It's so great to see so many colleagues, clients, friends, CEO alums here in our office today. And I know there's many more joining online. So thanks for being here. Fager Drinker is really proud to sponsor this event. We were talking today, trying to figure out how many years it's been, but it's been a lot of years that we sponsored this event, and it's one of our favorite events of the year. We're really excited today as well, because we got a great program today and a great panel today. And in that vein, I am going to stop talking because I want to pass it on. But again, just want to thank you for being here for these important discussions. And with that, I will turn it to Professor Deep Gulasekaram.
Thank you. Thank you, Joel. Thank you to Fager Drinker for hosting us. And let me add my welcome to all the people in the room and all the people joining us online. As Joel said, my name is Deep Gulasekaram, a professor of law at University of Colorado. I'm here today in my capacity as director of the Byron R. White Center for the Study of American Constitutional Law, which is what we're going to do here today. We're going to study American constitutional law, at least as it's told to us by the United States Supreme Court. Most of what the panelists have to say today will have to do with some aspect of constitutional interpretation, but also with administrative agency action and Supreme Court process. Obviously, we're not going to cover the entirety of the term, but we're going to select some recent trends and some important cases to discuss in depth. I thought I would start us off with some data on this past term, and then get into some of the substance of the terms. Much of what I'm going to say today can be also accessed on the SCOTUS blog StatPack, their StatPack publication, which looks back on the term and compiles data about this. So this term, the court heard 67, or I should say issued 67 total opinions, 50 with oral arguments. And there was one case that was a 4-4 case with one justice not participating. Just to give you some perspective on that, historically, in 1913 was the highest number of cases heard in oral argument at the Supreme Court, 312 in that year. But since that time, in the 1970s onwards, 1970s was about 180 per term. 1997, more contemporarily, court heard 102 cases. The Rehnquist court generally was hearing around that many cases per term. The Roberts court, especially over the last decade, has settled on a number of 60 to 70 cases for opinions during that time. Of the 67 opinions the court issued this year, 48 had dissenting opinions, which is a significant number of dissents. For those interested, here's some data on what the court term looked like this past term compared to prior terms. You can see the somewhat consistency with regards to how the splits on the cases go, with some variations that you can see here. Unanimous opinions this year, there were 28 unanimous opinions out of the 67 issued, roughly 42%. It's fairly consistent with prior years. I think the average over the past 20 years has been 45% of unanimous cases decided by the court, sometimes spiking to over 60 and sometimes as low as 29%. But of course, that doesn't really reflect the divisions on the court. There were 6 cases this year that split along what you might think of as typical ideological lines, now 6-3. And those were some of the cases that we'll be talking about today: Trump v. Casa, Mahmoud versus Taylor, Free Speech Coalition versus Paxton, Scrimeti versus Jackson. So many of the controversial cases were all 6-3 cases. You can see which justices were most frequently in the majority. Justice Roberts was in the majority 95% of the time. In close cases, 6-3 and 5-4, he was in the majority 90% of the time, followed by Justice Kavanaugh. There's a difference, a significant difference, obviously, when you're talking about total cases versus the closely divided cases. The two justices that agreed with each other the most were Justices Thomas and Alito, who agreed with each other in 97% of cases and 100% in closely divided cases. Justice Sotomayor and Justice Jackson agreed with each other in 94% of cases. For closely divided cases, Justice Sotomayor had a 0% agreement with Justice Thomas and Justice Alito. Justice Jackson had a 5% agreement with both of those justices. If you're curious to see how the circuit courts are doing, this is cases by circuit. It's not a significant enough number from any individual circuit to probably make broad judgments. The Supreme Court reversed in most cases that it took from all circuits. The 10th Circuit had a 100% reversal rate, but that's not unusual given the reversal rate of other circuits. The 5th Circuit, if you'd like to think about it that way, did the best in front of the Supreme Court this year. Okay, so that's just some broad data on what the court's been doing. I'm going to get us started actually with the substance of the Supreme Court review. Before I do, I'm starting us off. I'm both the moderator and now a panelist. Unfortunately, Aaron Van Oort, who's usually here, and I'm sure there are many Aaron Van Oort fans out there who came just to see him. I'm sorry that he is not here. I'll try and do my best imitation of him. But other than Aaron, we have lots of great panelists. We have Shannon Stevenson to my right. Shannon is the Colorado Solicitor General appointed in April 2023. Prior to joining the AG's office, she was a partner at Davis, Graham, and Stubbs, leading their advocacy department. She also clerked for Judge David Ebell on the 10th Circuit. She has her BA and JD from Duke University. To her right is Jonathan Skinner Thompson, who was also here with us last year, Associate Professor of Law at Colorado, specializing in administrative law and environmental law with a focus on air quality, climate regulation, and environmental justice. He'll be speaking about some of the environmental cases that the court heard this year. Also a graduate of Duke Law School. And to my far right, Blake Reed, a professor at Colorado Law, teaches at the intersection of telecom, internet, copyright, and disability law. He's also serves as one of the associated faculty at the Silicon Flatiron Center. And he is a graduate of University of Colorado Law School. Okay, so I'm going to get us started here. One of the things that Aaron was going to talk about, but that I will be now talking about, is the significant rise this year in the use of the emergency docket by the Supreme Court, sometimes called, perhaps controversially called, as the shadow docket of the Supreme Court, a term first coined in a law review article by Will Bode in 2015, Will Bode, professor at University of Chicago, and then popularized by Stephen Vladek on his blog, now Substack, and a book that he wrote in 2023 on the shadow docket of the Supreme Court. For those interested, on SCOTUS blog, Dean Erwin Chemerinsky of Berkeley Law School just wrote a short piece on the court's use of the emergency docket this term. For those interested, it's a critique of the use of the emergency docket. Why would there be a critique of the use of the emergency docket? So over this past term, there were 113 decided applications. So applications to the Supreme Court on an emergency basis. That's a significant rise from the years prior. But to break that down, to get something on the emergency docket of the Supreme Court, there's multiple ways it can get there. So stays of execution, some emergency applications from state and federal criminal trials. There's a whole host of other ways in which something can make the emergency docket, but perhaps the most significant part of this is that last part, when the federal government or the federal administration asks for review on the emergency docket. And so here, I think, is a more interesting illustration of the use of the emergency docket. You can see in the entirety of the George W. Bush presidency, there were 5 applications from the federal government, so from the administration to the Supreme Court over the course of 2 terms for use of the emergency docket, 3 by the Obama administration over 2 terms. The first Trump administration over four years, 41 attempts to applications to the emergency docket, dips during Biden, and then in the first 6 months of the second Trump administration, 21 applications by the federal government for emergency review by the Supreme Court. So it's a significant use of the emergency docket. For those, there are various perspectives on this, obviously. Those who critique this use argue that it allows for the Supreme Court to make decisions without much argument and on a quick or compressed briefing schedule. Oftentimes the orders are unsigned and without opinion, so that it's difficult to know what the reasoning of the Supreme Court is. That's not always true. Some of the cases we'll talk about today that are on the emergency docket did have opinions issued in them. And there can be significant substantive changes in law based on the emergency docket. One of the things that we might talk about today, or I'll mention, is that some of the cases on the emergency docket having to do with the president's ability to hire and fire federal employees arguably overrule Supreme Court precedent or make significant inroads into Supreme Court precedent. For those of you who remember or studied this, there's a case from a long time ago from the Roosevelt administration called Humphrey's Executor. And whatever one thinks of the soundness of the reasoning in Humphrey's Executor about the ability of the president to fire people who work in independent or administrative agencies, one might wonder whether it is okay for the Supreme Court on an emergency docket without a written opinion to essentially do what amounts to a significant paring back, if not a silent overruling of now a 90-year-old Supreme Court case. So those are some of the concerns voiced about this. Of course, I should say, if you ask Justice Alito, he would resist that characterization of nefarious things happening on the emergency docket of the Supreme Court. Okay, so to move on, here's again some uses of the emergency docket. These are some of the notable cases from the Trump administration thus far in just the last 5 months heard on the emergency docket. Some of the most controversial and highest profile cases of the term, including all of the cases having to do with immigration regulation and executive actions having to do with immigration, including the use of the Alien Enemies Act to remove people from the United States, putting them in a national security counterterrorism prison in El Salvador, plus several other actions by the Trump administration with regards to immigration. And then all of the cases having to do with the firing of federal employees, including a mass firing at the Department of Education, that's McMahon versus New York, and the removal of officers from the NLRB and the Consumer Protection, I forgot the name of it, somewhere up there. CS something. It's, what? No, it's not. It's a subdivision, I think, within that. Anyway, so one of those, 2 of those cases have to high profile at the very beginning of the second term, having to do with funding, the taking away of funding in the State Department, or the freezing of funding in the State Department. The Supreme Court split on that, with allowing the administration to freeze funding for future work by the State Department or by agencies, but preventing the administration from taking away funding for work that had already been performed by the State Department. And you can see there, that's the Department of State versus AIDS Vaccine Coalition. With regards to federal firings, these are fairly important, high-profile cases. As I mentioned, McMahon versus New York has to do with a significant layoff of Department of Education employees after a memo was issued in which it was at least stated in the memo that the purpose of these firings was to essentially hamstring the Department of Education and to take it out of existence through firings. Query, and this is a sort of an empirical question or a question that perhaps needs to play out as to whether the amount of firings that the administration is engaged in, that the Supreme Court has thus far said is okay, amounts to the same thing as dismantling the Department of Education. And I should say, in most of these cases, what the Supreme Court has done on emergency application is stayed the district court rulings which have found the firings unlawful, but do not issue at the Supreme Court a final ruling as to whether the ultimate firing is lawful or not, only that the cases, the litigation can proceed while the firings are still in effect. And so there very well might be another case that comes to the Supreme Court and certainly to the appellate courts in which the actual underlying substance of the firing is at issue. For most of these cases, the underlying substantive question is whether federal law that prevents the firing of people for cause is lawful or not. In most of these cases, there has been no claim that the firing is for cause by the president, but rather because the president or somebody in his administration does not agree with the person in charge or simply does not want that person to hold that federal office. For those who believe in the theory of the unitary executive, of course, this would be in line with that theory, that the head of the executive department has ultimate control over everybody who works in the executive department, and Congress should not be able to put impediments to their firing. Okay, and then the final area is the removal of non-citizens. This is where there's been a lot of press coverage, of course, including the firing, along with the firing of federal employees. And here, a lot of mixed opinions. Again, similar to the federal firings cases, the Supreme Court's okaying of administrative action, of the executive's actions here, mostly fall into the category of staying district court opinions, but not issuing a final ruling on the substantive merits of the administrative actions, but allowing the administration's actions to continue while litigation proceeds. One of the notable cases taken here, they're all notable, but obviously the removals under the Alien Enemies Act, which if you haven't heard of the Alien Enemies Act since you were in high school, it makes sense. You would have studied it when you were reading about the Alien and Sedition Acts passed in 1798, a series of 4 laws intended at that time to allow the president significant authority to do a whole bunch of things, but including remove non-citizens who were engaged in hostile acts of war against the United States. So here the claim is that non-citizens who are allegedly part of gangs or cartels are engaged as a foreign government in hostilities against the United States. And the final thing decided by the Supreme Court on the emergency docket, and I'll turn it over to Shannon, is the question of the ability of district courts to issue universal injunctions, sometimes known as nationwide injunctions. Trump versus Casa is the case. And the underlying question has to do with birthright citizenship. That's the thing that gets the headlines. The court did not answer that question, but did answer the question whether district courts can issue nationwide or universal injunctions. The answer the court gave, this was the split, was that district courts, the issuance of universal injunctions by district courts are highly disfavored, and took this case as the vehicle to make that ruling. We can talk about that in question and answer if people are interested, both in the substantive ruling and why it's interesting that the court chose this case to make that ruling. So universal injunctions, district courts, no in general. However, district courts, it said, can do what it needs to provide complete relief to the plaintiffs, which might in some cases involve universal injunctions. In fact, that's what the Maryland District Court, or no, the New Hampshire District Court on remand decided in this case. They can vacate an agency action, which might have the same effect, or they can certify a nationwide class action and then issue relief to that class, which again might have the same effect as a nationwide class action, which is in fact what the Ninth Circuit did on remand on this particular case, certified a nationwide class action and then enjoined the agency action. So I'll turn it over to Shannon to discuss substantive cases that are much more interesting.
Not at all. Well, thank you. Oh, do I need to turn this on?
Yes.
Thank you so much to CU and to Faegre for having us here again. This is kind of gotten used to doing this annually, and it's such a great program and fun to hear perspectives of all these folks on these interesting cases. And thank you, Dee, for just helping me relive the last 6 months of my life with that litany of cases. I'll move on to something less controversial here. Cases at the intersection of religious liberty and LGBTQ rights. I'm going to do my sort of disclosures here at the front so that you can all evaluate my presentation with my own biases in mind. Obviously, there are a lot of cases that the court takes on religious liberty and on LGBTQ rights, and then those two things often intersect or in opposition to each other. And for some reason, Colorado has seemed to develop a little regular Supreme Court practice on these intersection cases. So you guys might remember the Masterpiece Cake Shop case. That was where there was a baker who did not want to make cakes for same-sex weddings. Then the next case we had was the 303 Creative case, which involved a website designer who did not want to make websites for same-sex weddings. And now we have another case on this same front that's going to be argued this fall, which is Charles v. Salazar, which my merits brief is due in 2 weeks. So I'm very deep in the weeds on this. And this involves a Colorado licensed therapist who wants to do gay conversion therapy, which is banned by Colorado law. So she is challenging that as another. And all of these cases, interestingly, have been free speech cases, even though they usually start as both free speech and free exercise cases. But the free exercise claims have always gotten dropped before they get to the court. And they're really proceeding on a free speech theory, but with this sort of undertone of like, this is religious speech. So it's just sort of an interesting dynamic. So the way that the case is the child's case is presented at the court, as you can see, the question presented from the petitioner's view is, whether there's a law that censors certain conversations between counselors and their clients based on the viewpoints expressed violates the free speech clause. From our perspective, we see this as a regulation of a very specific healthcare practice that can involve speech, but doesn't necessarily, and think that it should be evaluated in that regard. So when you're, preparing and thinking about a case like this, obviously you're deep in the weeds on all of the First Amendment nuances and all of these things, but you also think about, well, what are sort of the more big picture kind of rules that might control an outcome of a case like this, with, sort of that most famous big picture rule being bad guy stays in jail, right? So I was like, oh, well, how are these religious liberty and LGBTQ rights cases shaking out? Because just thinking about it, the last sort of pro LGBTQ case I could remember was the Bostock case, where the court said, for purposes of Title VII, discrimination on the basis of gender, sexual orientation or gender identity is sex discrimination. But since then, this has been sort of the scorecard. So we have on religious freedom cases, we've got 14.5 cases going on the side of religious freedom. And then we have all 4 cases going against LGBTQ rights. And I don't remember how to multiply probabilities, but this doesn't seem very good for me. So what, we're doing our best. Okay, so with that perspective for me in mind, let's talk about the cases that touched on this particular term. The first one being United States versus Scrimetti. I suspect many people know something about this case, but this case involved Tennessee, a number of states, but in particular here, Tennessee and Kentucky, who had passed bans on medical treatments for gender affirming care for minors in their states. And the cases were brought by the actual minors, I mean, through their parents, and then the Biden administration intervened in the cases as well. At the district court level, both courts enjoined those bans and said, at least in part, they violated equal protection. That was reversed by the Sixth Circuit, and then the United States took the case up to the Supreme Court, which ruled along ideological lines and said, nope, there's these bans are okay. So let me try to sort of give you the perspective on what the arguments were on either side. So the petitioner said these laws violate the Equal Protection Clause in two ways. They discriminate on the basis of sex, and they discriminate on the basis of transgender status. And the articulation of the sex discrimination claim kind of following along from Bostock, right, which said, yes, if you discriminate on the basis of sexual orientation or gender identity, that is sex discrimination under Title VII. And so they said, look, here, if a biological girl wants to receive hormones or puberty blockers for the purpose of living and identifying as a boy, that's not allowed under the law. But if a boy wants to do the same thing, that is allowed. And it's sort of that question of like, well, if you have to know the person's sex to decide whether you can do the thing or not, that feels like it's that sex discrimination. And then the second argument was this discriminates on the basis of transgender status, which has never been ruled to be a suspect class under the Equal Protection Clause. So this was a first question of first impression. So the way the court, ultimately the court said, no, there is no equal protection violation. We're only doing rational basis review. And a state legislature that wants to protect minors from potential medical risks is gonna, always get past rational basis. So coming back to the sort of Chief Justice Roberts wrote for the majority, and his analysis with respect to the question about, is there discrimination on the basis of sex is here. So he says, although only transgender individuals seek treatment for gender dysphoria, gender identity disorder, and gender incongruence, just as only biological women can become pregnant, there is a lack of identity between transgender status and the excluded medical diagnoses. So in other words, even though only transgender people would want this type of care, not all transgender people would want this type of care. Therefore, it's not discrimination on transgender status, it's on whatever the medical purpose that you want to use the drugs for. And this, that reference there to the pregnancy is because he was relying on an earlier case from the 70s called Boulder, where there was a law that excluded treating pregnancy as a disability, but treated other similar things as disabilities. And there was a sex discrimination challenge brought to that. And the ruling was, well, no, this discriminates on the basis of pregnancy and not all women are pregnant. Therefore, it's not sex discrimination. So that is the outcome of discrimination. Next case is Mahmoud v. Taylor. This was a case where the school board in Montgomery County, Maryland, which is Baltimore area, decided to introduce a new curriculum that included a lot of LGBTQ friendly books and materials for all different ages throughout the school. And there were parents who challenged this and said, we don't want our kids to be exposed to this. We want a right to opt out if these materials are going to be around. And so they brought a free exercise challenge to these materials being in the school without their being allowed an opt out. Let's see. So again, we have another purely sort of ideological split on the court, your standard 6-3 representation there. Justice Alito wrote for the majority and held that, yes, that the presence of these LGBTQ materials did in fact burden the religious free exercise rights of these parents where there was no opt-out available. So a couple of interesting aspects about this case is, first of all, it was, and this happens a lot with these preliminary injunction cases, is you just have a really underdeveloped record in terms of what's actually happening. And so, it was unclear from the factual record in this case, are these books just sitting on the shelf? Are they being read aloud? Is there some sort of instructional program that's going along with the reading of the books? What does that look like? What age children are we talking about? All of those things were not clear. And the picture here is from Uncle Bobby's wedding, where Uncle Bobby marries his boyfriend Jamie, and everybody's happy. The other thing that was really interesting among the different justices is just how different the reactions to these materials were. So, for example, Justice Alito believed that these books were unmistakably normative and posed a very real threat of undermining religious beliefs. By contrast, I'm going to skip to Justice Sotomayor, who wrote the dissent. She said these, are just subtle themes in these books. They're just depicting people in their existence. There's nothing, normative or over the top about it that would interfere with somebody's free exercise religious rights. And a real underlying theme of all of this was like, what if you're in public school, right? Like how much sort of exposure to ideas or families or whatever that are different from yours is tolerable before that starts to interfere on parents' free exercise rights. And I guess one of the sort of funnier moments from the oral argument in terms of the sort of different perspectives was they were talking about this book for, pre-K kids called Pride Puppy. And this is a puppy gets lost at the Pride Parade, and he goes through, and each page has a letter of the alphabet where, they reference different things in the picture that have that letter of the alphabet. And at oral argument, Justice Gorsuch was talking to the counsel about, and he said, that's Pride Puppy, the one where they are supposed to look for the leather and things and bondage. Okay, here's the page. And there was a lot of publishing of these books in the actual opinion because there were such different views on this. You can see Pride Puppy the puppy's running through. He's L for leash and for loose and for leaping. There's a woman wearing a leather jacket, waving. And I guess the dog does have a leash on, but it's sort of a leap to get from there to bondage, I think.
That's on the B page.
Yeah, there is no bondage on the B page, just to be clear. So this is a tough case for takeaways because, again, we didn't nail down a lot of the details about what is it that is actually causing substantial interference and what factors are you looking at to find that in these particular cases. What's the relevance of the child's age? Obviously, people seem to think that older children can absorb, ideas that are different from their own better than a very young child. What's the moral framing of the content? How's it being presented in the classroom? And what are the opt-outs that are available? So I think all of those questions kind of remain out there. Last up, and this is the case that Deep mentioned, and this was the 0.5 case on the religious liberties. This is the Oklahoma charter school case. So I think 46 states have laws that allow for the creation of charter schools, and all of them provide that charter schools are public schools and that they are non-sectarian, meaning that they don't teach religion as truth. And this has been the way it's been for a long time. I'm sure many of you have interacted with the charter school world in a lot of different ways, but it's really become quite popular, especially in Colorado, among other places. So we actually led a multi-state amicus brief in this case on behalf of a lot of the states. So here, the petitioner was a school that the Catholic diocese wanted to form to be a virtual charter school. And so they applied to be a charter school. And there was some kerfuffle in politics on the board, and the board said no, and then the board said yes. And then the Attorney General said no, the Attorney General of Oklahoma. And then they went to the Oklahoma Supreme Court, and the Oklahoma Supreme Court confirmed, no, our charter schools are public non-sectarian schools. So then the charter school and the board went to the Supreme Court to challenge that. And the rationale here is following along this line of cases, Carson, Espinoza, Fulton, that you may be familiar with, where the court has basically said a number of times, look, if the state's going to provide a benefit, it can't exclude religious people or institutions from that benefit. So like in Carson, if Maine is going to give, and I might be missing this case, if Maine's going to give material for school playgrounds to all the schools, including the private schools, it can't exclude religious schools from that. Okay. So the argument of the school was, look, this charter school deal is a benefit, it's a program, and we want to participate in it, and we're just being excluded because we are religious. The counter argument on the other side was, no, if these are public schools, they're just like our other public schools, and we are heavily involved in the management of these schools. And if we have to have a religious school in this role, there's going to be a lot of entanglement. I mean, we're evaluating your budget, who your board members are, and all kinds of aspects of your curriculum. And that's going to create entanglement that is precluded by the establishment clause. So unlike everybody else who might want to start a charter school, we have establishment clause problems here. What was the answer? We don't know. Justice Barrett recused herself in this case, and the rest of the court voted 4-4, and we don't know who voted what way. We can probably kind of guess. My guess would be that Chief Justice Roberts joined the 3 liberal justices to make up one of those halves. And since the tie goes to the runner, and the Oklahoma Supreme Court had said that they could not have a charter school, that was the ruling that stood. I would flag that these issues will continue to come back. One of the lines of questions that kept coming up at the oral argument was sort of like, well, you say you want to be a charter school, but you've struck out some of the provisions of the normal charter, like the anti-discrimination provision in hiring, because you have a ministerial exception as a religious school. And, are you sure that you're going to really, are you going to get your charter and then you're going to say, well, I don't want to teach that part of the curriculum that's required because that violates our religious liberties, right? And we can see a lot of these cases already coming down the pike. We've got 2 of them in the 10th Circuit here for Colorado on challenges to our universal preschool program along these same lines. So I think these issues will just continue to bubble up. Last up, so here are our cases that we have coming up on these topics for the upcoming term. Childs v. Salazar, we talked about. West Virginia v. BPJ and Little v. Hecox are the equal protection questions on whether states can mandate that school sports have to be separated by biological sex, whether that violates the equal protection clause. So that'll be, I'm sure, very interesting and controversial one. And then one more case down there on our LUPA. And I will turn it over to Jonathan.
All right, thanks so much. I'm grateful to be here again. Last term or last year, I talked about the Loper case, which had overruled Chevron. The 2 cases that I have for today kind of bring us to some of the consequences of Chevron, or at least to the next step, but they're far less controversial, I think, and that's consistent with what Deep found in his review of cases. The 2 cases that I have, the first one was actually a 5-4 split, and then the second one that I'll talk about was a unanimous opinion, both involving environmental issues. So the first one that I want to talk about is the City and County of San Francisco versus the U.S. Environmental Protection Agency. This concerns a water permit, a water discharge permit that was issued under the Clean Water Act. So the Clean Water Act sets pretty ambitious goals. One of the primary goals of the U.S. Clean Water Act is that we'll have 0 discharge of pollutants into waters of the United States. In other words, we're not going to have any more pollution going into our waterways. Now, that was supposed to have been achieved in the 80s. We are long past that, and we still have discharge permits that allow some pollutants to be discharged into our waterways. And this is all managed through a permitting scheme that requires anyone to receive, or everyone to receive, a permit before they may pollute a waterway or discharge anything into a waterway. And permits historically have included numbers, numerical limits, and what are called narrative limits. So some examples of these 2 types of limitations that you might see in a water permit is 20 micrograms per liter per day for oil and gas. That would be an example of a numerical limit that you could see. So it tells the permit holder that, well, once you exceed 20 micrograms per liter, you violated your permit. So pretty straightforward target to meet. The narrative limits are a bit looser. Some examples of those have included no toxics in toxic amounts or free of objectionable color, taste, odor, or turbidity. So these don't provide a specific number that you have to meet, but they provide goals or at least ideas of what you're supposed to do as the permit holder. And historically, EPA and state permitting agencies, tribal permitting agencies have included both types of permit limits in their water discharge permits that they issue to industry, that they issue to cities, counties that might have wastewater treatment plants, et cetera. But before this permit requirement was added to the Clean Water Act, there was another requirement that was called a water quality standard. And this essentially requires states, EPA, tribes to develop standards for the water bodies that are within their jurisdiction. So for example, lakes in Colorado or streams in Colorado, there are water quality standards that apply to those that are tied to their specific uses. So some water bodies, for instance, might be used for fishing, recreation, swimming. You would expect the water quality standards that are designed to protect those uses would require cleaner water. You don't want heavy industrial discharge going into a water body that is used for swimming where people might consume some of the water. By contrast, you might have a water body that is designated for agricultural use, where you can tolerate a little bit more pollution, a little bit more dirty water in those instances because people aren't using it to drink or aren't likely to consume it in a way. So you can have different standards. Now, that water quality standards requirement was never displaced. It wasn't gotten rid of, but the permitting requirement that was added to the Clean Water Act is supposed to ensure that water quality standards are not violated, are not undermined. So permits that are issued have to ensure that water quality standards are met or at least not compromised. Now, here we have the city and county of San Francisco. They're a municipal discharger. They own wastewater treatment plants. So anything that goes down the toilet, down the sink, whatever you're discharging, it goes to these city systems or county systems. And they eventually treat it, at least in San Francisco. They have a very robust treatment scheme. They handle what happens if there's a heavy rain event, which might contribute to higher pollution loads because of street runoffs, et cetera. They have to get a water permit, and they got one for a discharge into the Pacific Ocean, which is the waters of the United States. And the waters of the United States for the Pacific Ocean, the water quality standards for them included recreation, fishing, swimming, et cetera. So a little bit higher than purely agricultural or industrial uses, or more protective standards. And notably in this case, they're the only permitted discharger to the Pacific Ocean. Nobody else has a permit that allows them to discharge into the Pacific Ocean. So that's the background of this case. City and County of San Francisco, for their wastewater treatment plants, has a water permit that says that there are some numerical limits in it, but they also have a narrative limit that says that they shall not contribute to a violation of the water quality standards of the Pacific Ocean. They can't cause the Pacific Ocean to violate the standards that are set by the state and by EPA. Well, San Francisco doesn't like this because they don't know what they have to do. They don't know whether, if after a heavy rainfall event or some other type of unknown issue, whether they might violate their permit. And so they challenge this narrative standard as being unlawful. And their argument is that under the Clean Water Act, there are no narrative standards. You cannot have any type of narrative standards, free and objectionable color, taste, odor, turbidity, no toxics and toxic amounts. All of those standards must be held illegal. And it goes up to the Ninth Circuit disagrees, says, yes, you can have narrative standards. They uphold the permit condition, and this goes to the Supreme Court. The Supreme Court decides in an opinion by Justice Alito that, yes, narrative standards are okay. They are allowable under the Clean Water Act. Now, Justice Gorsuch would have said that no, all narrative standards are illegal. But I think he and Justice Thomas, again, to Deep's point here, joined on this issue. But in an 8-2 decision, the Supreme Court says narrative standards are fine. You can have these types of limitations. The Clean Water Act allows it. What you cannot have is a purely end result condition. So the end result here being that water quality standards have to be achieved. And that's it. That's all that's told to the permittee. Those types of standards, those types of requirements aren't limitations. Now, this is a purely statutory interpretation issue. There's no Chevron deference at all. The court can decide these issues. It doesn't matter what EPA has thought or said over the years. This is, in a post-Loper world, a purely legal question that courts can resolve. And looking at the meaning, the ordinary meaning of the term limitation, Justice Alito says that's not a limit, this end result requirement. You have to tell the permittee what they need to do. So, for example, maybe it would be possible in rewriting this term or permit condition, a permitting agency, a permitting writer could say, San Francisco, city and county, you need to adopt best practices to ensure that the water quality standards are not violated. Whatever best practices are, that's left for you to decide as the regulated entity, but at least there's something for you to work towards, something for you to figure out whether you're doing what you need to do. And that may be possible. And Justice Alito says it should be up to EPA to figure out, or the state, depending on who the permitting agency is, to figure out what the permittees need to do. For the most part, write it into the permit. And then if that's true, if all that happens, we won't see mass degradation of our water. So he says, our opinion here today is not going to result in some increase in pollution. We can still meet all of the goals of the Clean Water Act. The agencies just need to be more specific. Now, Justice Barrett, interestingly, writes the dissent, and the other, what we would call the more liberal or progressive judges, they join on with her. And she says the majority gets it wrong. An end result limitation or standard is a limitation. The Clean Water Act only requires limits to be put into permit. And don't violate the water quality standard is a limit. And there may be good reason for us to allow permit writers to have or use more vague, flexible terms in permits, because it's really hard to draft and figure out what a specific technology or a numerical limit would be for different dischargers. Wastewater treatment plants in particularly are notoriously difficult to regulate because there are so many different factors that can go into their waste stream. And so it's hard to come up with a specific technology or a specific number to regulate their behavior. So leave it to them to figure out what they need to do. And this is especially important under the Clean Water Act, Justice Barrett notes, because there's the prohibition on any discharge into waters of the United States. If you don't have a permit, and you're not guaranteed to have a permit, you can't discharge, you can't release pollution. So what could happen potentially is that regulatory agencies that are short-staffed, under-resourced, can't write up these complicated terms, just stop issuing permits. And what would happen is nobody could release wastewater anymore into waters of the United States. And Justice Barrett is particularly concerned about that and says that we need to have some flexible conditions here for the regulatory agencies. And it's interesting that Justice Barrett, and I can talk about this a little more in Q&A, writes the dissent because last term there was a Clean Air Act decision when she also wrote a dissent with the liberals in a statutory interpretation issue under the Clean Air Act. And so she's an interesting justice to follow, I think, on environmental cases because she doesn't necessarily align with the other courts, other more conservative justice, especially when it comes to very narrow issues of what the text means and whether agencies should deserve any deference. So here's some more on that. The second case I want to talk about, the 7-County Infrastructure Coalition versus Eagle County, Colorado. This is a case that arose under the National Environmental Policy Act. This is one of the first or the first environmental law that was passed in what was called the environmental decade of the 70s. This was actually signed on January 1st, 1970, this law. Nixon didn't want to sign it on December 31st, 1969, because he wanted to kick off the new year and this decade. So we have this law, and it's designed to be, quote, purely procedural. It requires federal agencies to look before they leap, as some might say. It doesn't require any substantive outcome like the Clean Water Act, which is designed to reduce water pollution, or the Clean Air Act, which is designed to reduce air pollution. All that's expected is that federal agencies produce what's called an environmental impact statement, a document that examines the environmental impacts of a proposed federal action. So for example, if they're about to issue a license, a permit, come up with a forest land use management plan, et cetera, those federal agencies are supposed to think about what the environmental impacts of their decisions might be, consider some alternatives. It doesn't require a substantive result. So an agency could realize that their decision could have significant environmental impacts, but they're going to go forward with it anyway. Under NEPA, that may be okay, may not be under their other statutes. Well, in this case, we have a unanimous decision authored by Justice Kavanaugh. There's a concurrence issued by Justice Sotomayor, which differs on the reasoning, but the outcome's the same. Justice Gorsuch is recused. He, I believe, was friends with one of the developers that may have been impacted. So he stepped out from the case, didn't hear it. So it's an 8-0 decision in the end. The case involves 7 Utah counties that wanted to build a new rail line, about 88 miles, that would connect their lines to the national network. And the whole purpose of this line that they were building was to transport oil onto the national market, eventually make it to the coast potentially, and then the international market for oil. So the purpose of this expansion was to bring local oil and market it externally. Environmental groups were opposed to this, and they used NEPA, as the law is called, to challenge it because they argued that the Surface Transportation Board, which is the agency that had the federal role here, failed to consider upstream and downstream effects. And those specific effects that they claimed STB didn't consider is that the STB didn't look at increased oil production as a result of this line. We're going to drill more because now you can market the oil internationally. And they didn't look at downstream impacts of refining. We're going to have more refinery emissions in Louisiana or in other states because, again, more oil is coming onto the market. STB, the board, had declined to consider these because they said they're kind of outside the scope of this project. We're just looking at 88 miles of rail line. We'll look at the environmental impacts associated with that. We don't want to have to look at everything that could foreseeably be connected to this expansion. And the Supreme Court largely agrees with them. The DC Circuit did not. They said that these were foreseeable impacts or foreseeable effects because the whole purpose of this line is to market oil. So you need to look at increased oil production and downstream refinery emissions. The Supreme Court says, no, this is a purely procedural statute. You don't need to, federal agencies don't need to consider impacts of things that they have no control over. So STB does not permit refineries in Louisiana. They don't permit exploration activities. So it's reasonable for them to consider or not consider those impacts. And Justice Kavanaugh, interestingly, says here, last term we decided a case, Loper, that says courts are not supposed to defer at all to agencies on questions of statutory interpretation. But under the APA, the Administrative Procedure Act, courts should defer, must defer to agencies when they're exercising their discretionary powers. Deciding what impacts to consider in an environmental review document is wholly within their discretion, and courts should provide, quote, substantial deference. So a lot of deference to federal agencies. Judges shouldn't be coming in here and second guessing. And part of his concern with this second guessing is that NEPA has historically been used to block projects. Environmental groups or other groups have been able to use NEPA successfully to say and challenge environmental review documents that are arguably inadequate, and then the decision can't be made because the agencies need to go back to studying the effects. And Justice Kavanaugh doesn't like that. He thinks that the whole point of NEPA is purely procedural. If you want a substantive outcome, go turn to your other environmental statutes or go to Congress. So he's very critical of this. Now, the concurrence written by Justice Sotomayor comes out to the same outcome, but turns on the issue of whether the agency is authorized by their underlying statute, their enabling statute, to consider these effects. The board, as a common carrier, can't discriminate based on what's traveling down the rail line, whether it's corn, whether it's oil, whether it's toys. STB cannot consider any of that. So case closed. STB can't consider the environmental impacts of more air pollution because they're not allowed to discriminate anything. So their enabling statute should lead us to the same result. There's no need to consider those effects at all. Now, what's interesting about the majority opinion is that it leaves open the possibility, I think, of a future STB coming in and saying, yes, we do want to consider the impacts of refineries or upstream or downstream impacts, and courts need to defer to us. Those are foreseeable impacts, as the DC Circuit found, and we'd like to consider them. Nothing precludes us from considering it, would be one argument maybe, or at least maybe a different agency like the Forest Service and increased emissions. So with the majority's opinion, there's a lot of discretion left for the agency to decide what to do. With the concurrence, you have to really look closely at what the enabling statute, what discretion is left for the agencies to see whether or not something is within the scope of the NEPA. And that was decided 8-0, and I'll turn it over to Blake for our last couple of cases.
All right, good afternoon. So I have to start with a disclosure as well, but it's a little different than Shannon's, which is that I was a summer associate here. I had to do the math. It was 17 years ago. And frankly, I'm terrified. I'm right back in 2L mode right now. I see Dave Stark in the second row. I'm worried if I screw this up, I'm going to get sent to Dave's office. So bear with me. I'm going to get through it, but I'm really terrified. We've already had discussion of bondage, and now it is on me to discuss teenagers accessing internet pornography in Free Speech Coalition versus Paxton. But first, we'll do a case involving an even greater corrupter of minds, young and old, TikTok versus Garland. Some high-level themes before we start. The Supreme Court, believe it or not, does not like doing internet law. Justice Kagan, in oral arguments in Net Choice v. Moody in the 2024 term, she says, direct quote, "We are not like the 9 greatest experts on the internet." And indeed, for the first 25 years of the commercial internet, there's very few cases about the First Amendment's application of the internet. A law called Section 230 has preempted most state legislation that governs internet platforms. And then we had a trio of cases I'll talk about in a little bit, Reno, Ashcroft, and Ashcroft 2, which spiked the only major federal law that was in effect, the Communications Decency Act. And so for much of the life of the commercial internet, I like to say copyright is the only real law on the internet. Now, that was just a cheap excuse to do an ad break to say the Silicon Flatiron Center is going to be doing a great conference on AI and copyright on November 7th. We hope to see you there. But back on point for this, we will also see the court deciding whether internet service providers will be liable for secondary copyright infringement next term in Cox v. Sony. So come back next year. But for now, we are starting to see cracks forming in the dam. State legislatures and Congress are starting to put together laws to deal with the real midlife sorts of problems of the internet. Yet, much along the lines of what Jonathan mentioned in the environmental context, this is happening largely without the historic expert role of administrative agencies like the FCC. So we get states and we get Congress cutting straight to the policy bare metal and putting pressure on the courts to sort out the constitutional dimensions. So the court is really struggling in these cases to get its arms around the substantive laws, which are often badly drafted and in a rush. And then the court is struggling to apply the First Amendment because it has to apply these old precedents that come from before the internet that are now standing up to about a quarter century of extreme technological progress. So what do we see? The court is looking for ways to kick the can and rule narrowly. And both of these cases involve very specific and unusual laws. So a little bit tricky to assess what these rulings mean beyond the facts at hand. All right, last thing. Quick basics. If you're not a First Amendment nerd, what do we normally assess in a First Amendment challenge? First, we ask, does a law regulate speech? Second, if it does, we ask what level of scrutiny is required. And then third, we ask whether the law survives that scrutiny. But we also see these questions starting to collapse on each other in these cases. So if you find those inscrutable, you can say, yeah, the court is messing these doctrines up. It wasn't just me in my First Amendment class. Okay, let's move on to TikTok versus Garland. Someone had an idea that TikTok needed to be sold, and that person was Donald Trump in his first term. What were the major concerns? Well, TikTok is operated by a company called ByteDance, which is closely regulated, affiliated with the Chinese government. It collects data about American users, and there are concerns that TikTok may be able to manipulate the content that users see to push particular messages that might be sourced from the Chinese government. So Trump in his first term tried to ban TikTok and order it to divest its assets to a US buyer via executive order back in 2020. That was struck down in part. President Biden then during his term continued to work on trying to get TikTok to transfer its US operations to a wholly owned owned and controlled US company without ties to China. Now, flash forward to 2024. There is a classified intelligence briefing that really scared many members of Congress, in which they passed nearly unanimously right afterwards, as part of an appropriations bill, a law called the Protecting Americans from Foreign Adversary Controlled Applications Act, or as I like to say, PAFACA. I'm making PAFACA happen right here. So how does this work? If you have heard this called the TikTok ban, it is not a ban on TikTok. That's not how it works. If you put it on the quiz at the end, you will get a bad grade. How does this law work? It's a little complicated. All right, TikTok is classified as a FACA, a foreign adversary controlled application, unless and until it divests from any affiliation with the Chinese government. And that applies directly to TikTok. Like TikTok is mentioned directly in the law, as is ByteDance. And then the president can also designate new such applications. After 275 days, the law kicks in. Now, who does it regulate? First, it regulates app stores, and it says app stores cannot carry, Apple and Google cannot carry the TikTok app. It also says hosting providers, where TikTok's videos and other content are stored and delivered. Companies like Oracle and Akamai cannot host TikTok, but it does not regulate TikTok directly. $5,000 fine per user who accesses TikTok with your help. TikTok has 170 million monthly active users. The math is very tricky, but that means across the course of a month, we might be looking at the high hundreds of billions of dollars of liability, at least in theory. Okay, I said 275 days rather conspicuously, as though that random fact would matter. And it does, because 275 days happens to end on Sunday, January 19th. Can anyone think of something special that happened on January 19th of this year? I can. It was the last day of Joe Biden's presidency. Okay, what does that mean? So basically, we get a complicated series of timings, and I'll get into that in a second. But first, TikTok and its users, but none of the regulated parties, no Apple, no Google, no Oracle, no Akamai, sued, issuing a First Amendment challenge. The law was upheld by the DC Circuit, and then it went on to the Supreme Court for emergency review. Okay, we talked about the shadow docket. This is almost like a shadow docket case. It's not styled as such, but the briefs come in on January 3rd, oral arguments on January 10th, and then the Supreme Court issues an opinion on Friday, January 17th, 2 days before the law was set to go in effect. All right, so this is another per curiam opinion, unsigned, essentially 9-0, with a couple of largely agreeable concurrences from Justice Sotomayor and Justice Gorsuch, and it upholds the law. First, it questions whether the regulation of TikTok's ownership structure, this divestment, so is this really a ban on TikTok? we're not really sure this actually regulates speech at all. Again, Apple and Google, the providers that are regulated directly, not in the room. And there are questions right up to the bitter end about whether TikTok might find a buyer, might be sold. So the court says there's at most an indirect impact on TikTok's speech. The court punts on the question of whether speech is really being implicated and assumes for the sake of argument that it might be. Then the court says the law is content neutral both on its face and justified by a content neutral rationale. It says that data privacy rationale, protecting the TikTok users across America from having their data collected, that is a legitimate content neutral rationale. Well, what about this interest in stopping TikTok from delivering propaganda driven by the Chinese government? Gosh, that sounds like it might be content-based. The court sort of hand waves at that and said, this is a mixed justification case. We don't really have to worry about deciding that because we think that Congress would have passed this law on the basis of the data privacy rationale alone, and because the data protection argument is reasonably well supported by the record, the law survives intermediate scrutiny. All right. Now I've got to give you a messy sequence of events. Friday, January 17th, the same day as the opinion, TikTok threatens to go offline. An unnamed Biden official declares that the Biden administration will not enforce the law before the end of the term. On Saturday, January 18th, TikTok service goes down in the United States. Apple and Google remove the TikTok app from the app stores. America's teenagers freak out. Not yet President Trump, President again Trump, then goes on Truth Social and asks the companies not to let TikTok go dark. On Sunday, the law goes into effect. It's the last day of Biden's presidency. TikTok comes back online. Some of the hosting providers decide to roll the dice and rely on that Truth Social post from then not President Trump. Then on Monday, President Trump is inaugurated. He issues an executive order instructing the Attorney General not to enforce PFACA for 75 days. Then at some point in the next several weeks, non-prosecution letters go out to the App Store and hosting companies. On February 13th, Apple and Google suddenly put TikTok back in the App Store. On April 4th, the deadline is extended again for enforcement to June 19th. On June 19th, it is extended yet again to September 17th. It is today, August 5th. There is no deal. We have no idea what will happen. Enjoy TikTok while you can. All right, I see that I've only got just a couple of minutes, so I'll go very quickly through Free Speech Coalition versus Paxton, which is all about a Texas age verification law, one of about 20 similar state laws. It requires commercial pornography websites defined as sites that have more than 1/3 of their content sexual material harmful to minors to verify the age of visitors, block minors from proceeding, and display health warnings about the addictive qualities of pornography. All right, there's a somewhat surprising result. The court upholds the law 6-3, majority opinion by Thomas and a dissent by Justice Kagan, joined by Justice Sotomayor and Justice Jackson. So why is this a surprising result? Well, the last time the court did an internet law First Amendment case back in ACLU v. Reno, and then the follow-on cases of the Ashcroft and Ashcroft 2, the court struck down very similar laws under strict scrutiny. But here the court says, no, this law is different. The Communications Decency Act that we struck down in the 90s banned sexual content for minors, and then it allowed age verification as an affirmative defense. And this law is the other way around. It's an age verification requirement first and foremost. I think that's a distinction without a difference, but Justice Thomas finds it compelling. And I have to say the best thing I can say for Justice Thomas' reasonings here is it's going to be really fun to torture future generations of students with it because it doesn't make any sense. He says, well, first, age verification requirements are just a traditional police power. Adults don't have a First Amendment right to avoid age verification. That's not affecting their speech. But then the court says, well, we're not going to do rational basis review, which is normally what we do if speech is not implicated, because there are incidental impacts on the speech rights of adults. So shruggy emoji, we split the difference and use intermediate scrutiny. That's like 10 pages of the opinion. I saved you, don't worry. I really recommend reading Justice Kagan's opinion, which tries to make sense out of the majority. Anyhow, intermediate scrutiny is applied and it survives. Why? If you are in class, you haven't done the reading, protecting the children, always a compelling government interest. We don't need to worry about less restrictive means like parents doing content filtering because we're not doing strict scrutiny. We're doing intermediate. The court dedicates about a paragraph to the question of whether age verification is actually going to work. And you might ask, what about the giant privacy risk of requiring age verification on every single adult website? The court says, don't worry, the industry is going to figure it out. And indeed, these laws are now gaining momentum. In addition to those in the United States, we now have the Online Safety Act imposing similar obligations in the UK. And with that, I'll turn it back to Deep.
All right. Thank you, Blake. So I'm going to go, before I open it up for audience questions, just quick lightning round for each of our panelists. I'm going to give you the questions and then you guys can take them in the order that you went. So Shannon, it's sort of really interesting about the number of cases you said. One, you had noted about in the cases that you were talking about, the claims were free speech cases as opposed to free exercise cases. So the first question is there anything at stake in that, in presenting the case as a speech case as opposed to an exercise case? And the second question, partly related maybe, is that, you know, the broad trend of cases you're talking about, essentially, one might say minimize the establishment clause at the expense of the free exercise clause. Do you see in your litigation or in Colorado, religious groups, perhaps with progressive ideals, trying to utilize the free exercise clause in ways that progressive groups have not to achieve the ends that they want for pro-LGBTQ rights or other types of, right? So that's the question for you. For Jonathan, this gets a little beyond your presentation today, but last year you had spoken about the overruling of Chevron in Loper Bright and some of how it's played out in the two cases that you're talking about today. What can we say in general 1 year on from Loper Bright? And then finally for Blake, so age verification laws in general, right, in the non-internet world have been around for decades, right? Maybe, I don't know, yeah, I'll say decades. So is Free Speech Coalition just an odd case in the application of age verification because it's online, or is the argument broader that age verification should not exist even in the brick and mortar world?
Okay. It's a memory test. Something of free exercise and free speech.
So the first point, yeah, it was about whether there's anything at stake in these claims being free speech as opposed to free exercise claims. And then are there progressive groups using their free exercise right for ends that are usually not associated with the free exercise right?
So I actually think there's more at stake on the free exercise claims, which is why I think people are dropping them when they get to the cert stage. If you guys are familiar with the case, and I have no area of expertise, so so I know just enough about this to be dangerous, but there's a case employment division v. Smith, which basically says if you have a neutral, generally applicable law that incidentally burdens religion, that doesn't violate free exercise, right? Nobody on the court seems to like that case, and I think there is a strong tendency to either say it's already been overturned or we're going to overturn it, and nobody knows what the result of that will be. It'll probably be something more favorable toward religion, but I think given that sort of uncertainty in that area, the way I see, and a lot of these cases are brought by very organized, very sophisticated groups that know these laws inside and out. And the way I see it is, if you bring the free speech claim, as I was kind of talking about, you sort of get the benefit of the fact that it is religious speech. Like, I think people just react to it differently than if it were speech about a political issue or personal issue or whatever else. So you almost don't need the free exercise claim to get the benefit of having it be religious speech. It sort of feels like it's bolstering your free speech claim a little bit, kind of subconsciously.
Mhm.
So I think that's sort of the strategy. to your second question, and I'm trying to think of how it would work. I don't think I've seen any cases brought from the left
Mhm.
to sort of utilize these types of principles. But also, I think you just see less of that from the left generally, because if you're trying to get to the Supreme Court to sort of make big sweeping change from the left, like now's not really the time.
Mhm.
So I think they're mostly playing defense.
Thanks. So what's happening post Loper? There was a study of the first 6 months following the decision that was just came out in the Minnesota Law Review by Professor Robin Craig at Kansas, and she identified three observations from her from the empirical analysis of lower court decisions. And the first observation she made was that state courts, they're not necessarily champing at the bit to do the same thing. And part of that, I think, is because state administrative law is a bit more nuanced. They have different rules playing out and different constitutional provisions that may be governing whether or not a Chevron-like type of review is appropriate in those states. And so we're not necessarily seeing the same thing play out in state courts. For the lower federal courts, what we are seeing is some divergence in terms of the standard of review to apply. Some courts are following what the Supreme Court had suggested was Skidmore. Others have rejected Skidmore altogether. And others are not sure what to do with our deference now. So that's the idea that courts should be deferring to agency interpretations of their own regulations, which was upheld recently in the Kaiser decision from several terms ago now. And then the third observation is that agency rules are not faring very well. So I think she had identified maybe 80% of agency rules were overturned, vacated in light of the post-Loper decision, and agency orders, so legal interpretations that are coming out through agency adjudications, they tend to fare a little bit better than agency rulemaking, which is interesting. And so those were her three observations. One thing that's happening in the enforcement world is notable, at least in environmental enforcement. The Trump administration put out an executive order that directs agencies not to enforce rules that are not based on the best interpretation or best reading of the statute. So even though Loper, the court in Loper said, we're not overruling all of those prior decisions that relied on Chevron, if the underlying regulation was upheld as a permissible interpretation of the statute under Chevron Step 2, agencies will not necessarily be enforcing those regulations currently, at least under the Trump administration. So we're seeing some things play out certainly in the courts, but I think what's even more notable is how the administration is approaching those ambiguously adopted regulations.
I'm going to jump in on two questions and violate your order here. Just on the first
As
question,
is your right as a law professor.
indeed, but only to extol to your attention the work of a colleague on the question of free speech and free exercise and the sort of tension in the court's recent jurisprudence. I highly recommend Margot Kaminsky and her co-authors have a piece in the Yale Law Journal called "From Gods to Google" that explores this exact question in great detail. Good reading afterwards. So age verification laws have been around forever. What's different online? Should age verification not exist in the brick and mortar world? Deep, you really channeled Justice Thomas like almost word for word in your framing of that question, and that is exactly the majority opinion in Free Speech Coalition. Justice Thomas looks back to a case about brick and mortar bookstores, Ginsburg, where we apply a rational basis to age verification, and says, what's the difference here? And moreover, if we cut back on age verification on the internet, there's no limiting principle. We're going to put age verification laws in the real world at risk as well. All right, let me make a quick argument for what's different. One is data collection, right? So when you go into a brick and mortar store, there's a lot of identification that happens informally, right? We don't know canonically exactly who you are and exactly what your age is. A lot of it is clerks making just judgments based on your looks, or maybe quickly looking at your driver's license. That looks pretty different when we do it online, and a website might be anywhere. And we're uploading a photo of a driver's license, saving it in a database. So we've got pretty extensive data collection and retention that doesn't happen offline. And then we've also got the potential for enforcement, right? Because this can basically be the Attorney General examining of Texas, in this case, examining conduct that's happened after the fact, right? So we can examine what you have stored, what you have retained, and how you have kept people on or off the website after the fact in a way that's more or less impossible to do in the physical world. So I think that's the difference, but obviously the majority did not see it that way.
All right, thank you. We have about 8 minutes. So if there are questions, yeah, there's.
Okay, we have one here.
Great.
Blake, you mentioned it briefly, Cox v. Sony. Do you have any predictions for what the Supreme Court's going to decide in that?
All right, so real quick, Cox v. Sony preview for next year. The question is, can an internet service provider, which are normally eligible if they dot their I's and cross their T's for the safe harbor of the Digital Millennium Copyright Act, if people are doing things like downloading songs or movies illegally on their internet connection, this is a case where Cox has fallen outside of the safe harbor, and we have to confront the old school question of whether there is secondary copyright infringement. I have no predictions about how the court's going to mess with this. Like, are they going to know what an internet service provider is? We shall see. Come back next year. Thanks for the teaser.
Other questions?
Hi, thank you all for coming. Shannon, question for you on LGBTQ and religious cases. I've been fascinated by 303 Creative, the website designer case, Kennedy, the praying high school football coach case, by what seems to be a pattern that these cases are not very factually supported. They're test cases brought by organized groups, but in the 303 Creative case, it looks like the website designer maybe didn't even receive a legitimate request to make a website. Maybe she wasn't even a website designer. Similar issues in the Kennedy case. Do you have any general thoughts on the court's willingness to consider these cases despite those issues? And in the, I forget the name of it, but in the conversion therapy case, are you seeing similar issues?
Yeah, this problem is like one of my banes of my existence right now, are these sort of, like you said, test cases. They're brought on a preliminary injunction motion, often with no real evidence at all. I think we've been sort of doing better and thinking about defending them of really trying to like ask for as much discovery as we can possibly get at a PI stage. And so, for example, in the Child's case, we put in hundreds of pages of expert materials on, why conversion therapy is harmful and ineffective. And the plaintiff put in nothing, not even a declaration from herself, right? So we have what she says in her complaint, and that's it. It's troubling to me that the court isn't more troubled by it. And also that, another aspect of these cases, and this is both in the First Amendment and Second Amendment context, there's so much information coming in that are through law review articles, through amicus briefs. And that stuff can be helpful or relevant, but it's not evidence, right? And so in a lot of these cases, you'll see, like, for example, in the Scrimeti case, I think in both of the district court cases there were extensive PI proceedings with big evidentiary hearings and hundreds of pages of factual findings that almost just it's like they didn't exist. And they're really coming at these questions on a very narrow legal, resolution that is not really looking much at the facts of the case. And it's frustrating to be in my position and dealing with that situation. So. Yeah. Thanks for letting me vent.
Quick echo the frustration from the outside. In 303 Creative, there's another variant of this, which is the keystone of the case is that it is indeed expressive for a website designer to have their imprimatur on a website. Like, designing a website means you're affiliated with it. And that's based on a stipulation that was made very early in the trial court that I think in context didn't mean that at all. It was the court sort of says, oh, they conceded the core of the First Amendment issue. I think not so.
Yeah, no, it's difficult. I mean, you can see, and a lot of times these cases are coming up through like blind attorneys who aren't thinking about, they're just trying to do a good job and litigate their case for their agency client and thinking, well, this will help us get to a resolution of the issues in a more expeditious way, right? Without thinking all the way down the road to the Supreme Court, which is, not where most people are thinking when they first start a case. So.
Hi, my question can be fast, but it was also for Shannon, and it has to do broadly with, do you have any advice on how to deal with that frustration, just working on a case and knowing that you have a very much uphill battle, and like, how do you not get frustrated? And the question kind of came to me with the whole bondage and the pride dog, like how how are you handling that frustration of just thinking, why are you looking at this through this lens?
And I'll take it back to maybe just like a more general piece of advice for anybody who does litigation of any kind, because, you can have frustrations like that, whatever your area of practice is. Some of the things that help me are to think like, whatever job you're doing, like your job has a specific role. Like my job is to defend the laws of Colorado now. So that's what I'm going to do. And that's what I'm going to focus on. I'm going to do it to the best of my ability, right? If you're a public defender and you are up against all kinds of institutional challenges and frustrations in the case you do, your job is to defend the rights of that criminal defendant to the best you can and to hold that system accountable as best you can. So I think trying to focus on your role and what you can reasonably accomplish is one way to just sort of get some peace from from what you're doing. But I work in a great office with great people doing great work, and that's a joy and a pleasure. So
Yeah, hi, my name is Ben Binder. With respect to how the justices make decisions, what percent of their decision is based upon the facts and the law as opposed to their ideology?
Empirically speaking, gosh, I don't know. I struggle to make any broad claims about that, but I think I just point to Free Speech Coalition as for some explicit discussion of that between the justices. And indeed, you see Justice Kagan basically accusing Justice Thomas of starting from the intended result to uphold the law and reasoning backward, and making a fairly convincing, I think, sort of inductive logic sort of explanation for how Justice Thomas has done that. So I think it certainly happens. It's just hard to say in general.
One thing I can add at least with regards to the immigration cases that were decided on the emergency or shadow docket is that you can see perhaps they're like the justices, the so-called conservative justices, wanting to uphold the immigration action substantively. But one could argue that they are being bound at least by the procedural posture in which the case has been raised, and therefore struggling to get to that result within that structure, which is why you're not getting actual substantive end results, but ways that are narrowing the possibilities for relief for plaintiffs. So shuttling immigrants making claims into particular courts. You can only raise your habeas claim in Texas. You cannot raise it in Washington, D.C. You can ask for relief through nationwide class actions, but you can't ask for it through a universal injunction. And so I don't know if that's a response to your question, but there is in some sense a constraint, at least procedurally, or at least through vehicles for substantive results.
Another question concerning the record on appeal. I was always taught that in preparation for my oral argument, I had to know the record cold, right? I would often have notes pointing to particular parts of the record. The Supreme Court seems to be straying outside the record in many of the facts that they recite in their decisions. Is it worth it to object at oral argument to something being outside the record? And if so, what if the court rejects that? What's the remedy?
So I asked this exact question to Elizabeth Prelogger about a month ago, because she had that issue. This is the just passed Solicitor General of the United States. She had that issue come up in a number of her different cases at oral argument. And I think the answer was make the objection that it wasn't in the record really quickly and then deal with the substance, because you're just not gonna, just the record issue is not gonna win the day for you.
Just a two finger to say, I think your initial impulse though is still correct. We see some examples where unsophisticated appellate lawyers at the Supreme Court don't have their notes straight, don't have the record straight, don't have it straight. For example, in the net choice case last term, which companies your law applies to of your state, things like that, important to know. So I still think the impulse of knowing your facts called is the correct one.
Yeah, I was gonna, we'll wrap up here, but if you listen to the arguments in district courts, in the immigration cases having to do with the use of the Alien Enemies Act or the removal of people for their speech, the Mahmoud Khalil case, the district court has on multiple occasions chastised the government attorneys for just incorrect statements of the underlying facts of the case or incorrect statements about the government's power over non-citizens. What can you do about it? I'm not sure, but at the district court level, one thing that's become clear in those cases is that those district court judges no longer trust the government attorneys and their representations as to what the government's powers are, or even where the non-citizen is being held, or how long they've been held, all of those things. So it actually, in one case, got turned against the government because they made the representation that they could not bring back non-citizens that had already been deported. And therefore, on that basis, the Supreme Court said, well, now we have to halt all deportations underneath this act because you've represented in court that you don't have the ability to bring back non-citizens once you've deported them. And if you can't bring them back, then we can't let you remove them in the first place. And so, that's not a contemporaneous sanctioning of the untruth, but it is something that redounds ultimately to the detriment of the attorney making that representation over time. That's in hindsight and over time sort of reputational concern, not a immediate sanction sort of concern. We are over time is what Georgette is telling me, I think. So please join me in thanking the panelists.